Hello everyone, and welcome to today's webinar, What You Should Know About Contracts and Waivers. Presenting today is Christine Taylor, partner at Towne Law Firm, and she'll be speaking on contracts for us today. After her portion of the webinar, I'll go over how the new ResNexus Premier Contract tool works. Then at the end, we'll have a period of time set aside for questions. Christine, thanks so much for coming on, and I'll pass it over to you.
Thanks. So I'm Christine Taylor. I am a partner at the Towne Law Firm, but in addition to being an attorney, I am someone who grew up in the outdoor hospitality business. So my parents bought their first campground when I was 9 years old. And after I went to law school and came back, I realized that there were a lot of things that we could be doing more effectively and more legally, really. So today I'm hoping to cover some of the most talked about kinds of different contracts and paperwork that you might need in operating a business. And I know that it might not all be feasible right away, but if we all make strides to being better, it'll help us protect ourselves and our businesses moving forward. So, why contracts? Contracts can help you lessen your liability. So if there is something that you spell out there, or if there is a law in your state that allows you to waive negligence or other things like that, you're going to need some kind of written document for that. And that'll help you have less liability in the event something happens. Two, in some cases, you need a written document to abide by your state law. So that could be that this promise doesn't count unless it's in writing, in which case you need that. Or it could be you can only use the benefit of the statute if you have something in writing. So in those cases, paperwork and contracts help you abide by the law. It also is great to help set expectations, whether that's between you and your employees, you and vendors, or you and customers. If you kind of lay it all out there, then both parties to that document are aware of what is happening, which leads to 4, where it creates trust among the parties. So if I know that Sally's supposed to do X, Y, Z, and Sally knows that I'm supposed to do 1, 2, 3, it helps us trust each other because we know we have this piece of paper that we can refer to if something goes awry. So what are types of contracts? Types of contracts include employee contracts on whether or not you should have them, long-term agreements, which could be with people who are licensing or leasing something from you for a long time, a work order, which could be either internal, maybe you're doing something for a customer or guest for you, repairing something, moving something, something like that, or with an outside vendor. Vendor contracts like clothing or store stock or entertainment or somebody fixing something, those kind of contracts. If you are able to rent your facilities to some kind of other thing, like a wedding or a corporate retreat or something like that, you want to paper that up. And then the one that everyone kind of talks about are releases and waivers. They're technically different things legally, releases, waivers, and assumption of risk documents, but in plain English, we tend to use them interchangeably, but we'll get a little bit more into that later. All right, so employee contracts, pros and cons. So generally, most states in the United States are at-will employee states, which means that I can fire somebody for anything that's non-discriminatory. So that means like I can't fire someone because of their race or their religion or their national origin or their gender, but I can fire someone because they are a bad employee. And I don't even have to generally have a reason, as long as it's not one of those discriminatory ones, to fire someone. But if I put something down in a contract, then I have now turned it into a contractual relationship where we're no longer at will, which means that I could only fire or terminate that contract with that employee pursuant to what we put in writing. So I couldn't just decide that Sally isn't working out the next day and fire her, because now we have set this term and these steps in this contract. In some ways, that's positive for some people because it does set a term and expectations. So if you have a staff member that you want to be there definitely no matter what, May through October, and they tried to quit, they technically also couldn't just quit for no reason because they were obligated to fulfill their half of the contract, which was to get to the October date that you had set. So in some cases, some people might like that because it binds both you and employee to these terms of this contract. If you don't want that scenario and you want them to stay as at-will employees, then I would recommend that you do what we call an offer letter. So it'd be like, Sally, welcome to Team TLF. You're going to be in the position of housekeeper. You have an expected start date of this date. You're going to work roughly these hours during the week. These are your duties. Here are any benefits you might get. And then this kind of is infringent on making sure that you have all the appropriate documents or a background check if that's what you're doing, and the handbook upon hiring, whatever those onboarding documents are. That way we know when they're starting, we set an expectation of what their role is and what their general expectation is, but we didn't kind of lock ourselves into an agreement that we can't get out of. So it's helpful in that case to only have these little pieces to kind of set parameters. The handbook document is important because in some states it's legally required to have an employee handbook, and there are legally required things that have to be in that employee handbook. And what's missing from an offer letter, you can also put in that employee handbook. So instead of talking about what sick days you have or don't have, or what requesting off looks like for vacation, you can put that in the handbook instead of the offer letter and have those together kind of put the whole relationship into writing. So keep that in mind that most people, it would be a con to have an employee contract, but if you find it something that is beneficial to you, then you should think about it. The one side little piece to think about in this scenario is a lot of people traditionally have employees that live on site or are newly looking at having employees live on site. If you're going to do that, it might behoove you to have what we call an employee leasing agreement, which outlines the fact that their housing is tied to their position at your business. So in the event that you did fire them, that they would no longer have housing and hopefully would either expedite or avoid the eviction process depending on your state laws. So that's kind of a brief overview of employee contracts, pros, cons, and what kind of documents you might want together to protect yourself. All right, the next one is what I call long-term agreements. But what they really are could be, if you're a campground, a seasonal agreement. It could be for boat slip seasonally or anything like that. If you are providing any kind of like housing, I guess, for lack of a better term, or a place where they could put a camper that someone could try to argue that it was housing, this is when it's very, very important to make sure that this document is not a lease. Now, there is some state-specific rules that length of time of stay would trump any kind of document, but as a general practice today, I'm going to encourage you to think of your relationship with your customers as a licensee-licensor relationship. Why? Licenses are revocable in all 50 states at will. So what that means is if I don't want that person to be there anymore, I revoke their license and now they're trespassing. When you go to a baseball game or you go to a parking garage, on the back of those tickets, they usually list some terms which kind of lay out that you are merely getting a license to park your car there, you use that seat for a time, and that if you did something wrong, like break their rules or created a ruckus or whatever it was, they could revoke the license and you would no longer be entitled to be on their property anymore. So we want to try to shift more towards that. We want to show that there's no way this could ever be housing, that there's no kind of real property interest, that they don't own anything. We're merely giving them a license that I can revoke at any time to use that space or rent that cabin or whatever it is. I would say the general rule is the farther your language is from an apartment agreement, the better you're doing. So no landlord, no tenant. Instead of rent, try license fee. Instead of eviction, try revoking the license or ejecting the guest. Language really matters in the law. So be very, very specific in what you're putting in there and take a look at what you have. Is there any way somebody, court or otherwise, could read into your agreement and think that you were giving that person something that you didn't intend? If that's the case, then you need to kind of clean that up and do something different. It also, as we kind of stated in the beginning, helps you set expectations. So if you have a refund policy or a no refund policy, you can put that in there. If there are specific rules that apply to this relationship, you can put it in there. You can put an expected term length that this money only gets you from X to X. Newly, since the pandemic, I guess that's not that recent anymore, but it's new in the legal perspective that we spend a lot more time looking at force majeure clauses. And what those are those kind of acts of God clauses you see. So if your clause didn't include pandemic or government shutdown, probably should now, if you don't want to be bound by a contract that you can't perform on because of one of those things. You want to have the stuff that you might have to reference state-wise. So, for example, in Pennsylvania, if you're a campground, you can revoke this agreement and get rid of the person and have the help of some law enforcement. But one of the statutory requirements is that you also post that statute. So, if you're going to try to rely on those state laws, then you need to make sure that you're following whatever those parameters are. So I guess another example is in New York, if I want the law enforcement to help me remove somebody, I have to have given them a written warning first. So my rules have to model that statute if I want to take the benefit of that statute. I would generally also recommend, especially recently, that you kind of lay out both what statute might cover this and what your internal policy is regarding abandoned property. We've had a lot of people leaving things on other people's property, and you want to make sure that you kind of have that covered as well. So again, we're setting expectations. It builds trust with your guests from the perspective that they know what you're going to do and they know what they're supposed to do. So you can't just pull the rug out from underneath them, but it should also help protect you in the event that you need to get rid of them. So that's kind of something to think about when you're doing some kind of long-term agreement with somebody. Okay, so work orders, I kind of think about this in two categories. Internal would be a guest or customer hiring you to do something. So is that putting gas in a boat, filling up a propane tank, pumping out the black and gray water from an RV, something like that. If they are doing something with you, I know that the general practice was these like lists of little signups where it's like, Sally paid me $10 to do this, and that was it. But I would encourage you to probably be a little more specific about where your liability extends or is cut off in the event that you either harm their thing, whatever you're doing the work on, or that their thing harms you. So I would take some time to look at that. I know it seems a bit voluminous for things that you're kind of doing off the cuff, but it is important. For example, I had a client who was doing a honey wagon pump out of a camper, and they did it somewhat interestingly. And the way the camper was manufactured, it had an kind of a failure in it, I guess would be the best way to describe it. And it caused massive damage to the camper. Their insurance company has said because there was no agreement and because they took on the liability of doing this service for them, that the business's insurance has to help pay for the repair of this camper, not the camper's insurance. So it's really important to try to limit your liability by figuring out where your liability kind of cuts off. So that would be the internal piece. External's kind of the same thing. If you're hiring somebody else and, for example, they bring a work crew with them, I would want to know that they have insurance, or if that person tripped over something on your property, that they'll indemnify you from one of their workers getting hurt on your property. It's really important to make sure that I wouldn't be liable for what someone else on my property is doing. If your guest is hiring someone else to come on your property to fix someone, I would either kind of have an approved list of vendors that, these people have insurance, that they would indemnify you, etc., or let the guests know that they have to make sure that if they're going off that list, that they're going to hire someone who meets those parameters. Again, this is kind of about lessening liability. Now, as I said at the beginning, it's a movement towards being better. I know that overnight we're not going to suddenly have documents for everything, but it's something to think about. And if we could start introducing some of these documents, maybe you only do it for external stuff to start and don't do it for internal stuff. But whatever you can do to help your business be protected is really, really important. All right, so vendor contracts is kind of similar to some of the work order stuff in the indemnification land. But the other part I want people to think about is to look at some specific provisions. Now, I'm an attorney, and I generally don't read all the fine print in a lot of contracts. Most people don't, and I totally get that. They're voluminous, there's a lot of legalese, it's frankly quite boring, and we only have so many hours in a day. But if you're only going to do the abbreviated look over, I would recommend that you look at a couple things in particular. The number one thing is termination. If you adore the vendor at the time you sign the contract, like any relationship, you're probably not thinking about how you're going to get out of it at the end. But you should, because if there are long cancellation periods, or if the vendor can cancel on you at any time without any repercussion, you want to know, because you want to know what you can rely on and what you would have to do if it wasn't working out anymore. That's the same kind of thing for pricing. Is it locked in? Am I locked in at X price for the year? Am I locked in at X price for the shirts, no matter whether their supplier raises their costs or not? You want to know if it's locked in, or if conversely, they can increase it at any time for any reason. Now, this seems unusual, but it has happened in some cases where the cancellation period is you have to give them like a year's advance notice, which seems ridiculous, or they can just raise the price as the market fluctuates, which means you don't ever know what you're paying in advance. Those are not contracts that you want to get locked into. So please take time to kind of look at those things so you've set your expectations correctly about what it is. The other one that I like to throw in there is entertainment contracts. Most people, if they're hiring a local band or something like that, don't get something formal, and that's okay. But if you're doing anything like this, you should get something in writing, even if it's just an email. And I would try to confirm some stuff, like what date are they coming, and can they just switch dates, and how long do they have to be there? And if they decide that they don't want to come to your facility anymore because someone's paying them twice as much money, are you SOL, or do they have to find a replacement, or could you, not that it might make economic sense, but could you sue them if they didn't appear? You kind of want to have that in mind as well. And again, pricing. Did you lock in the pricing, or can they be like, well, now we're in high demand, so we're going to double the price? So whatever kind of vendor it is, take some time to look at some of these provisions so that you know what you're stuck with and what you can rely on. All right, so we are going to have a great party. Maybe it's a wedding, maybe it's a corporate retreat, but whatever it is, we should probably have some kind of document. So this could be a couple scenarios. So the first one could be someone just renting your facilities for their own wedding, and that they're going to then, I guess for lack of a better term, subcontract out the other people, caterer or whatever, that's going to do it on the property. You should have an agreement with them that says that they are getting your facilities, what you're providing and not providing, and again, that they will indemnify you for anybody else getting injured or something on that property. That includes those other vendors, like a caterer or a DJ that those people are hiring. If they're allowed to hire whomever they want, and especially in a wedding, I'm sure that's what they want, then you want to make sure that those people, if they got hurt, would sue the people who contracted with you and not you. Now, granted, nothing in the world stops people from suing you. If they want to sue you, you'll probably be on that lawsuit. However, having these kind of agreements makes the lawsuit get dismissed against you much quicker than if you didn't have anything. I would also recommend that you set a stipulation that anybody they hire has to have their own independent insurance, again, such that their insurance would pay out in the event something happened instead of yours. There is another scenario, which is when you rent to a party that rents again. So I have a client who has a restaurant on site, and they don't run the restaurant. They rent the restaurant to another person. And that's great. You can totally do that, have an agreement. But that restaurant also will rent out to events. Again, it sounds a bit like a chain and a domino type situation, but you would want to make sure that your agreement with those people who are renting out your restaurant, that if they rent it out to other people, that again, you're being indemnified up the line such that if something happened, you as the landowner aren't the one being sued. So have those events, but also have the paperwork that limits your liability such that you won't be in trouble if somebody gets hurt. All right, which is a great segue into one of our most hotly talked about topics everywhere, which is waivers and releases, sometimes also called assumption of risk documents. So they very obviously limit your liability. You need to know that they are very, very, very state specific. In some states, the font size, capitalization, and bolding of the very language can decide whether or not your waiver / release is worth anything. So as much as I encourage people to get education and share things among themselves, I would recommend that if you want this document to be as best as it can be, that you have a state attorney in your state look it over, because it's very, very specific. Now, there are some states that technically say these documents aren't worth the paper they're printed on, at least in conjunction to certain activities. And then people say to me, why would I still have that document? There's a couple of reasons. Number one, it can't hurt to have one. Why? Most lay people don't know that the waiver isn't worth anything. So it acts as a deterrent. Your guests, customers think, hey, I signed this document, so I can't sue them. And then they don't. You know, it's not our job to educate them about the law. So if they don't know that, it can act as a deterrent. That's number one. Number two, it can act as what we call an assumption of risk document. That's why you've been hearing me say that, which means that we outline why that activity they're participating in, whether it's boating, camping, hiking, etc., is inherently dangerous and that they chose to do it anyway. Thus, if they got hurt and they sued you, you could be like, hey, we outlined why, this is dangerous and why you might get hurt, and you signed that you understood and you did it anyway. So again, that would be really helpful in your defense. The last piece is that your insurance company may require it. So some insurance companies do require some kind of document, and in which case they might have a template, but go back to what we talked about in the beginning and kind of refer that to a state attorney to look over to make sure it's okay. The last thing is kind of where to get one. No, not everybody wants to pay an attorney. I get that. We're one of many line items when you're discussing your business, but I would be very, very careful in where you're getting them from. So AI is really hotly talked about right now, and if you're going to have nothing or an AI generated one, then do that. Something is better than nothing. But if you don't know the exact things you're prompting for, you might not get something that's great. My weird little cheat suggestion that I tell a lot of people is to find something in your state that would have had an attorney look at it. So what do I mean by that? If you go to a college's webpage and they have a waiver for food trucks being on their property or something like that, chances are that a big state university had an attorney look at that agreement before it went out. So the odds of that being something that you can steal for your own needs are higher than if it was somebody who just put one together themselves from a copy and paste job. So kind of look at that piece. But kind of ancillary discussion to this is just because you have paperwork doesn't mean that you're protected from being sued. And I totally get that. But there's a lot of other pieces that we can do to make our defense better. So we have the paperwork. That's step one. Step two is to have those rules, policies, and procedures. So what do I mean by that? If we're going to pick something inherently dangerous, let's say a rock climbing wall that we have on our property, then I have a waiver before the people do it, or at the very least an assumption of risk document that says you're partaking in this, and these are the dangers that could happen, and you're choosing to do it anyway. Step 1. Step 2 is I have rules. You can't do it after you're in a swimming pool and you're wet. You can't do it as a piggyback. Any of those type of things, whatever would make that activity safer. So we have those rules, but then the next piece is enforcement of that. So if you're going to have rules, you actually have to enforce them. And your staff has to be trained to enforce them the same way every time. So that way, in the event that somebody was hurt and your staff was called as a witness, they could be like, no, I know that these are the rules. I enforce them at every time. This is how it's done. So they're a great witness for you, because if I can say that when I was enforcing those rules, Sally was breaking all of them, and she signed this document outlining her risks, and she got hurt, it's a lot less likely that she's going to recover because I showed all the reasons why she shouldn't. The very last piece about people getting hurt is having a point person who can address that situation appropriately. Now, some, again, insurance companies have kind of a guide, but you should be very careful on who your point person is, because statements that they make during that time could be used against you as the business owner. So the point person, when there is an injury, should know what they should and shouldn't say, should know the things that they should and shouldn't do, and the information that they should be collecting. What kind of information should you be collecting? You should take your own pictures of whatever the thing is that happened. If there were any witnesses, you should take down their names and numbers so you can contact them for witness statements later. If there are any other extraneous things that you would want to remember when you were defending your lawsuit, you need to put your file together. People then say, Chrissy, how long do I keep these files? And in some cases, it's quite a long time. If it is a child that is hurt, although this is state specific, there are times in which they can wait all the way until they turn 18, and then the statute of limitations start running. So that could mean a decade plus in some instances where the person is not suing you for a very, very long time. So although it seems excessive to keep paperwork for a long time, if the person is hurt and you have knowledge of them being hurt, please save it until the statute of limitations in your state has passed, such that you have all of the documents you need to support yourself. So, as I said, I am a law firm. We do a lot of this paperwork for a lot of people. It runs the gamut, but all you can do is help yourself. So if you have nothing, start with some of them. Start what might be most pressing. Maybe you have more long-term guests than situations with employees. Maybe you have lots of employees and not very many long-term guests. Pick the thing where you think you have most of a weakness and work on it now, so that in the long run, you have the documents to provide to either that insurance company's lawyer or your general lawyer, such that they can defend you in a lawsuit. Thank you very much for listening today. And if you have any questions, please feel free to email me at info@townelaw.com or give us a call. And if I can't help you, hopefully I can connect you to a source that can.
Thank you very much for that presentation, Christine. That was a lot of fantastic information, especially for this industry. Now I'm going to go over ResNexus Contracts, which is a new feature we're very excited about and have put a lot of effort into. But first, let's get into the most common use cases we have for this tool. First is long-term or ongoing rentals for campgrounds. As we continue to expand into the growing campground industry, many of them have sites that are rented out all season long or even longer. Often, they'll have staff that are living on the premise as well. We just visited an RV park this month that had plenty of long-term RVs that had clearly been there for a long while, so it's fairly prevalent in the industry. Next up is marinas. Like campgrounds, most boat slips are rented for long periods of time and need more legal protections than just your average booking, especially if you're living on the lake or ocean. Property management companies need software to manage long-term leases. During the pandemic, when remote work was at its peak, many families were looking for long-term leases. Vacation rentals were also going into month-long bookings. In many states, when you cross a certain stay threshold, you need a lease agreement. For years, we've had properties who also do tours or have motorized vehicle rentals. We've all been there, filling out the paperwork so we can go jet skiing or ATVing. If you haven't, the first thrill is all the papers you have to sign. Which leads us into liability waivers, meaning on the property side, you can email a liability waiver contract out to guests and have them sign it. Why? Well, again, with motorized vehicles, or really with any other kind of vehicle or activity, including kayaks and things of that nature, often the rental contract is with one or two individuals. At the end of the day, our goal with ResNexus Contracts is to help your property save time by automating the contract process. In addition, you can have one place where all your contracts are stored and linked to guest data, along with any required documentation. Now I'll quickly show you how you can get started with ResNexus Contracts and how it works in ResNexus. The first thing to know about ResNexus Contracts is that it's an advanced tool only available to subscribers at the Premier Edition. As with all ResNexus settings, you can find contracts on the settings page here, or you can simply type the word into the search bar at the top. Or you can also access it from the left-hand side panel. The Templates section of Contracts allows you to view and edit all of your existing templates, as well as add new ones, which we're going to do right now. For this example, let's say you have a zip line on your property, so you need guests to sign a liability waiver before they can use it. You'll type in the contract's name and select liability waiver as the type. New contracts come preloaded with content text, which you'll of course want to change before you can send it out to guests. You can copy and paste your text from another document, or you can start from scratch. And you can also format the text using the options at the top. Remember to click Save Changes before navigating to a new page. The next tab over takes you to options for this template. Here you can select which documents are required, such as driver's license, proof of insurance, or any other documentation. You can also select whether this template is used for ongoing reservations and whether vehicle information is required. And then in the Party Fields tab, you can specify what additional information is required by the contract parties. You can add requirements, remove requirements, and move them around. Back on the template screen, we can see that our zipline liability waiver is listed here. Note that once a contract has been sent out to other parties, you can no longer edit it. If you need to revise your contract, you'll need to duplicate it first and then edit the new one. You also cannot delete contracts that have already been sent out. If you navigate to the Search Contracts section of Contracts, you can view all of your sent contracts. And here you can view which ones have been sent and signed. And of course, each one of these contracts came from one of the templates we saw previously. And if you click New Contract at the top here, you'll be able to select a contract and send it out to the relevant parties. First, you select which template you're going to use, or you can add a new one from this screen, and then you select the contract dates. On the next step, you can add parties to the contract. Your business is always a party for any contract you make. The information displayed here is pulling from your business info setting, so if you have to make any changes, that's where you'll want to do that. When you add a party to a contract, you select whether they're an individual or a business, and then fill out the relevant information. You won't be able to proceed with sending a contract unless it has at least one other party attached to it. You can select which units are assigned to the contract if relevant, and you can add fees and vehicles as well. So for this long-term RV lease example, I'll select one of the units. You can then set the rate type, set it to weekly or monthly. We'll do monthly in this case, and then we'll click Save. While we're at it, let's also add a fee for a background check. Just select it from the drop-down menu, and then you can click Save again, and you can also add new kinds of fees as well. Now let's add the vehicle, since this is an RV side lease with an RV. You can select the type of vehicle and the color, and input the vehicle's length and license plate. Now, this is very useful because this actually integrates directly with your reservation calendar. Units added in this contract will automatically populate your grid and calendar with the booking for the selected dates. So that's very useful for those long-term leases I was talking about. On this next step, you can select which documents are required and add new ones. Then you have the payment step. If a payment is required for this contract, you can add that here, or the other party can submit payments on the guest portal. And finally is the review step, where you can preview the contract to view it in the same way it will be viewed in the guest portal, and you can email it to them when it's ready. When you click email, you can customize the email subject, add a personalized note, and choose which email addresses it will be sent to. And here's what the guest portal side of things looks like. The other party will be invited to confirm their identity, make a password, and then sign the contract and submit payments if necessary. And that's pretty much a brief overview of the new contracts capability of ResNexus. Again, it's only available to subscribers at the Premier level. We'll get to the Q&A in just a moment, so get your questions ready. But first, I'd like to say that if you enjoyed this webinar and would like to view any of our past ones, you can do so by going to our website, resnexus.com. When you scroll to the bottom, you'll see a Webinars button, which will take you to our entire library of past webinars. You can also register for upcoming webinars on this page. All right, and with that, we've come to the end of the presentation, and now it's time for the Q&A. So if you have any questions for ResNexus or for Christine from the Towne Law Firm, you can go ahead and submit those now, and we'll try and get those answered for you as fast as we can in the order they appear. While we're waiting for questions to come in, I just wanted to say thank you again to Christine. I thought that was a really, really great presentation, so thank you very much for that.
Thanks, I appreciate it. Always fun, sort of, to talk about legal issues or contracts.
It looks like we have a question. Someone says, hello, you said the contract feature is only available for certain plans. Yes, so currently ResNexus Contracts is only available to properties who are subscribers to ResNexus at the Premier edition. So we have 3 editions. There's Essentials, Professional, and Premier. And yeah, Contracts is only available for Premier. I have a question for you, Christine. What states are you aware of that don't accept liability waivers?
So, unfortunately, the biggest one I know is New York, where I sit. So what that generally means in New York, for example, the way the law has to do specifically with recreational activities, which camping gets shoved under, that if you pay for the activity, that the waiver doesn't count. However, you should still have a document, because if you outlined the risks and they were aware and they did it anyway, as I said, it is a deterrent document. So even though the statute says that the waiver itself doesn't like automatically make the case go away, it does make your defense better. So, you know, that's when the definition of waiver, release, or assumption of risk document matters to us as attorneys, even though it doesn't really matter to you, is because in New York, what I'm really creating for someone would be kind of an assumption of the risk document. And I'm outlining that there's risks, because a waiver from a legal sense and practice wouldn't work to just make things go away. So.
Okay, interesting. Sounds like there's a lot more that goes into it than meets the eye. Okay, we have a question. When creating a contract in ResNexus, can you pull info from a reservation tile if the reservation is already made, so you don't have to enter it all in? And the answer is we do not currently support adding a contract to an existing reservation. However, you can automatically pull in the guest info. You just need to fill the unit information in. Another question for you, Christine. What have you seen in regards to weddings or corporate events going bad? Just not fulfilling the room requirement or commitment, or things of that nature?
So honestly, some of it has to do with something as simple as like an injury, right? So if someone got hurt, let's say a guest of the bride and groom on your property, they're going to try to sue everyone possible. Now, what if the bartender overserved that guest? Or what if the bride and groom know that guest had a propensity for falling in public places, if you will, or things like that? I'd want them to either indemnify me from that liability or share in it, because I'm not the one who served them alcohol. I'm not the one who brought somebody who was incredibly litigious on the property. You know, I didn't get to vet every guest that they brought. So in that case, that's why I'd want some agreement that they share that responsibility. So it could be things that you're dealing with on your own, but you know, if it was your own guest, you got to vet them. So a slip and fall, you know, it could be damages, like they hurt, broke something in your space, or I was actually at a wedding 2 weeks ago that had these votive candles on the table, and this woman flopped her purse down on top of a candle and didn't notice, so it briefly caught fire for a minute. So, you know, weddings can be a pretty interesting event. So having an agreement with somebody that they share in that responsibility, whether it's financial, you know, for your damages, or it's protecting you in a lawsuit, you know, those are the kind of things you want to cover.
Right, that makes a lot of sense. And yeah, of course, it's weddings when all the crazy stuff happens. All right, another one for you, Christine. If for an employee contract, if the employee doesn't fulfill the time term of the contract, what do you recommend as kind of the penalty for that? Like a fixed fine, or what do you suggest?
So you can do a couple things. You could put in that contract what the penalty would be. That's kind of those liquidated damages you hear so much about. Or you can just have it, you know, be something, what those actual damages are to you. So, you know, if they were supposed to be there till October and they left in August, and to get somebody to fulfill their position from August to October, you had to spend X money on advertising the position and Y money in addition to, you know, more on a salary than you had paid that person. You have real damages that are calculable in that sense. So you could also put something like that, what like actual damages are. So your choices are liquidated damages, that's putting that pre-prescribed penalty in, or the actual damages, which are what it might cost you to kind of replace them and fulfill that term that they weren't willing to do.
Okay, great, thank you. All right, and it looks like we've come to the end of our questions. So thank you one more time for everyone for taking the time out of your day to learn more about contracts as well as the new ResNexus contracts. And thank you to Christine and the Towne Law Firm for giving this presentation for us. And I hope you all have a great rest of your day.
Thanks, everyone. If you have any questions, please feel free to email me at the email you see on the screen, and hopefully I can help you out.
Great. Bye, everyone.